Well, we've got some rain happening right now, but hopefully that is going to get out of here pretty soon.
It is going to taper off just in time for the commute tomorrow morning, so some good timing. Great sleeping weather, though. If you want to check in on the radar, of course, you can do that on the WAAY 31 Storm Tracker weather app. Your chance for rain Monday, again, very early in the morning. We will see a little afternoon sun. Still a bit chilly in the 40s, but that is as cold as we've got on this 10-day forecast. 50s and 60s pretty well the rest of the week. And as we take you on into next week as well. Another weather maker coming in next Friday. Should get that one out of here early into next weekend. And then look at that, some upper 60s next Sunday and into the following week. That'll be the warmest that we've seen so far here in 2025. Again, Grayson tomorrow morning with the newest update for you.
Absolutely. Well, don't forget, WAAY 31 gives you 24/7 coverage you can count on. We'll be back in the morning.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviat. Tonight it's Ask Us Anything night, so whatever legal situation you're finding yourself in, every legal problem is unique and you've probably got questions, whether you can face this on your own, whether you need to go visit with a lawyer, whether this is something negotiating with an insurance company or anything else. What do you need to do? Tonight's your opportunity to call and ask car accidents, medical malpractice, 256-536-0077. Call, or you can now text us to that same number. We've got some of your text messages waiting. You can also email us any day of the week. You send it to lawcall@waytv.com. And when we get to a show that's on point, we pull out some of your email questions, and we have some of your email questions tonight. Michael Timberlake's here from Timberlake League and Brooks. Good to have you here.
Yeah, I got the short straw. I gotta be here answering anything.
Anything at all. So we're going to start off with, while we get our calls in, some video. We like to give you tonight's, let you make the law call show. We've got some video that we've pulled off of YouTube. A guy that's out working, doing his regular job, some digging. He's putting, looks like working for a fencing company, digging and putting in some posts. Unfortunately, he does not know that there is a gas line under there.
Ooh.
And he's going to be okay, but the explosion is significant.
Yikes.
So something like this, if he's just a worker that's digging where he's been told to dig, is the landowner in any way responsible for something like that? If I hire a company to come out and put in some post holes and put in some fence posts?
You know, we've actually had this case.
Oh, really?
I had a construction worker that was working on a site that had been, I mean, you know, the way you handle it is you contact the utilities, the county or whoever is in charge of the gas service there, and then they come out and they mark the lines. In this case, they came out and marked the lines, and they didn't mark the area where he was digging.
Oh, gee.
And it, you know, they tore up the gas line and it caused an explosion.
Okay.
Fortunately, he was okay.
Good.
But in that situation, you know, obviously we looked at it was a county situation where we looked at county workers who had, improperly flagged the gas line at their request. The landowner in that situation is only going to be responsible if they knew the gas line was there and forgot to tell it to the other person. So, they're only responsible for problems that they know about and don't tell. So if they happen to know there was a gas line underneath the fence line, they should have told them, and if not, then they're not going to be responsible in that situation.
We got in some text questions for you already. Do you have to insure your house for the amount the insurance company wants?
Good question.
Is that the deciding factor?
You know, typically what most insurance companies are going to require you to do is purchase replacement value of at least 80% of the value of the house in that situation. That's just the way insurance companies work in terms of the amount that you're going to need, or they're going to offer the minimum that you're going to have to purchase it to insure that property. Now, if you have a mortgage on the property, they may require that you, make sure that you insure it for at least the amount that you owe the mortgage company under that situation. If the house should be destroyed, then you're going to have at least enough to pay off the mortgage in that situation. But typically, the rule that we see is 80% of the replacement value.
Seems like a pretty good rule.
Yeah.
We got this email question. This is from Grace. Grace wrote in, I informed my employer of black mold at my office. The facility has a history of mold and water leaks, and a mold specialist was involved in the past. There's a crawl space or AC vents behind my wall, and the problem was just brushed off. And my manager decided it must be that I'd spilled something. Well, that's false. And I said so in an email. The next day it was cleaned and waterproofing was applied. Does not appear that any further action will be taken. Before this was discovered, I'd been experiencing a deep cough and other respiratory issues, which I assumed was just a cold. Is there anything I can do? That's a lot of information.
Yeah, it's a
Where do you
lot,
start?
of information. I mean, basically, from an employment situation, she's, she can move jobs. If she cannot, that's become a problem for her, then it will be up to her. Her employer, in some circumstances, if the ADA is applicable, may have to accommodate a particular type of disabled or physical condition that she has, but she'd have to prove that something about her physical condition made her susceptible to this environment. You also look at the situation about okay, is the black mold, is it something that caused this problem? And that's in our community, there's a lot of wetness, there's a lot of dampness, and there's a lot of different things in the air in general. So what she's going to have to prove is that her problems were a direct result of what happened at her employment, and if that's the case, she could prove that it was materially in excess of what you would get in the normal world just walking around. Then you could potentially make a claim for workers' compensation benefits. But those claims are hard to make because of the level of proof you have to have.
Yeah, sounds like an expensive thing to prove.
Exactly. You're getting a situation where doctors will look at a diagnosis and say, well, certainly that could contribute to it, and then when they're pressed by lawyers, they're like, well, it could be something else.
Could be something else. Okay. We've got Elizabeth on the line with a question from Decatur. Hi, Elizabeth. Thanks for calling. What's your question tonight?
I have a question about diminished value with
Okay.
an auto claim.
Okay.
I had an audit fault accident, and they are paying for the repairs, and they're complete. And they have offered me a small amount of money for diminished value. Seems to me like it should be more than it is. How do you know how much it should be? How do you figure that out? Do I need representation? I'm not sure how to proceed.
You bet. What is
Yeah.
she even talking about? Diminished value? What does she mean?
Yeah, basically the value of a vehicle, if it's been damaged in a wreck, the value of the vehicle is going to, or the value or the measure of damages that you're entitled to is going to be the the cost of the repair plus any diminution in value of the vehicle, any reduction in value of the vehicle, and that would, in theory, make you whole. They'd fix your vehicle, and then they'd pay you for whatever the reduction in value is. Now, the reduction in value is hard to, kind of pinpoint. There's people on the internet that say they will give you a affidavit of whatever the reduction in value is. People have said they've taken their cars to dealers, but dealers are reticent to get involved in these situations. They don't want to put anything in writing. They don't want to go to court. Insurance companies will have their own company, basically, that works for all the insurance companies, assess what they believe the diminution in value is, and it can be, almost nominal. You look at the year of the vehicle, the types of repairs that were done. Was it a situation where the repairs could be done satisfactorily? Really what you're talking about are the things you look at in the diminution in value. I mean, we see it, typically 10 to 20%, of the repair cost.
Okay.
In some situations, if it's a particularly, if it's a historic, historically significant car.
Gotcha.
Chris's T-Bird,
Okay.
it does a little bit of different things.
We got this text question in. Remember, you can text into the number as well as call in. My son has sole custody. Is he able to give his mom custody if he dies? Okay, family law question, so I can help you with that one.
So it's like children, not personal property,
Yeah,
right?
you can't hand it down like you can leave a vase or you can leave real estate. If your son passed away, a grandparent would have to actually file something and prove not just that this grandparent would be a better parent to the child than the mom, but that the mom is unfit. So it's not, because otherwise you'd have people filing and saying, I could be a better parent to your child than you are.
Right.
The courts won't go along with that. But it might be that if your son knows some things about the mom that he needs to make you aware of, give you some evidence, if he were really ill and you're planning ahead, make sure that he's helping you have the evidence that you might need to file and say that mom is unfit.
Yeah, and our state had historically recognized some grandparents' rights and visitation, things like that, and then they've come off of it pretty hard.
They have, but there's still circumstances where a grandparent, if the child's parent passed away or were unable to be part of that child's life, a grandparent can step in and file and ask for grandparent visitation. It just depends. You've got to have the right circumstances, and it keeps changing. They keep changing the law because it keeps getting challenged. But if you're in that circumstance, go visit a family law attorney and talk through it and see if there's something you need to be filing for. We've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, I missed getting on the show last week about the TikTok.
TikTok, yeah,
ban.
you guys talked about TikTok last week.
Yeah, and what I want to find out is, from what I understand from the news, the main complaint that the U.S. government has is that the Chinese government can demand data, personal data on all the TikTok users. And I don't understand how that's legally possible, since my understanding about a year ago, all the data that's stored on TikTok is now stored in what's called Project Texas. Oracle Corporation, that's located in Austin, Texas, apparently has servers or computers that have all that data. And if the Chinese government were to try to force them to produce that data, I can't see how they could be contractually obligated to give that data up, since they're a U.S. corporation. Is there any reason why that should be so?
Well, I mean, I think the question is, is whether this is accessible to a foreign government that is an adversary of the United States. And obviously, I haven't seen the evidence that was presented to the United States Senate, the United States Congress, potentially the President of the United States when the bill was signed. But apparently, it was compelling enough for it to be basically unanimous that this go through. Whether China has access to it or potentially has access to it would be the question. And I think you'd have to ask yourself, okay, if it's digital data or things that could readily be passed without somebody knowing about it, is there a back door? Is there some way that the Chinese government can manipulate the TikTok or the parent company in order to provide the data? And I think that's what the question is. I don't know. I don't think all the information that is out there in the press, and so it's hard for me to make a decision about what would be the right thing to do.
I always wonder what my Alexa pods are collecting on me too.
Yes, exactly.
All of those things. We're living in a new time.
It will hunt you down and tell you need tennis shoes.
Yes,
exactly.
It reminds me all the time that something I looked at before is now on sale.
Especially if you talked about needing tennis shoes.
Ooh, that makes you uncomfortable,
Yes,
doesn't it? Makes you squirm. We're going to take a break. We'll be right back. We've got some callers on the line. We've got some text questions waiting. Be right back. It's Ask Us Anything night.
You're watching Way 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Meservey, and hosted by broadcaster and family law attorney Sharon Doviet. This is Way 31 Law Call.
Tonight, it's Ask Us Anything night. Michael Timberlake's here from Timberlake, League & Brooks. They are personal injury attorneys. So that's everything from car accidents, medical malpractice, pharmacy errors. What else?
Premises liability, construction accidents, workers' compensation.
Anytime
fraud.
you get hurt, somebody else caused you to be hurt.
Somebody done you wrong.
Done
we can
you
help.
wrong. We've got Norma on the line with a question from Huntsville. Hi, Norma. Thanks for calling. What's your question tonight?
My question is there a limit of time for a will to be processed?
Limit of time for a will to
Will
be
to be
processed.
probated, I believe it is 5 years.
5 years?
Yeah, so
Yes.
you have 5 years from the date of the death for a will to be probated under those circumstances. Now, typically you want to, if somebody passes away, the family would want to present the will for probate as soon as possible. That way it allows you to pass the property down in the will as soon as possible. There's some extraordinary circumstances that require a delay that might give you some leeway, but in general, 5 years is a pretty long period of time. So you're probably not going to be able to do anything if you exceed that point.
They were telling the folks in the booth someone passed away 20 years ago. So that will is too bad.
Gone.
Yeah. So
Gone.
things have been resolved, and the will is.
Yeah.
It would seem like you could.
Well, and by that time, what's happened with the property?
You can't just leave it sitting for
Right.
20 years. Okay. How about this one? You're talking about some new case law about loss of use for a vehicle. What are you saying is the new change?
Well, so basically, we have, if there's somebody that's involved in a motor vehicle wreck and your car is a total loss, it's not being repaired, it is totally unable to be repaired. Insurance companies would typically pay you for the loss of the use of your vehicle for a consumer, just a normal everyday vehicle. Up until the point where they would make an offer to settle the property damage. So if they're, takes a week to move the car, get it assessed or whatever, they'll pay for your loss of use for a week, which is typically renting you a car. This case came out of the Alabama Supreme Court last week that said, no, if it's a consumer, if it is not a business use for that vehicle, there's no provision in Alabama that requires them to pay for loss of use. So if it's a total loss, you're kind of on your own in that situation. Okay. Now you can protect yourself by getting rental car insurance on your own policy.
Okay.
But the other person's not necessarily going to be responsible to pay it.
Got this text question. Was in a vehicle accident in an adjacent state where I sustained injuries. Is it important that I retain a lawyer who practices in that state, or can Alabama lawyer represent me? Which is a better choice?
Well, I mean, it really kind of depends upon the gravity of the situation. If you, at the end of the day, the attorney in the other state is probably going to have more leverage and more influence over an insurance company, or if the case has to be litigated, you're going to need somebody licensed in that state to present your claim. But if you are inclined or know somebody or have confidence in somebody that's local to you, you can contact that lawyer and they can make arrangements to work on the case with somebody from another state. So, sometimes it makes sense to have somebody that's local to monitor the situation, somebody you trust in that type of situation. And most of the time, those lawyers will say, hey, there's not a lot of work to do here, or I can't really render a lot of assistance, but I'm going to put you in the hands of somebody that's good, that I know, that can take care of the case. So, if you know somebody local, it's always a good place to start.
Yep. Okay. You were telling me that you have had a case recently, a truck versus pedestrian.
Right.
And the vehicle, so the truck hit the pedestrian and then the truck driver fled.
Exactly.
Serious injuries?
Serious injuries.
Okay. What do we do in a case like that when the
Well,
vehicle flees?
so what we've done is we've done a lot of investigation on the front end to try to identify the other driver. And if that can, and possibly will bear fruit, that driver's insurance company would pay up to the limits of the liability coverage for damage that they've caused. But if we can't find that driver, Alabama would deem that person to be a phantom motorist, somebody that is unknown but existed. And as long as the person that's injured could say, yes, I was hit by a car, and they had uninsured or underinsured motorist coverage at their house on their vehicles, then they can get the benefit of those vehicles because they were injured as the result of a use of an uninsured motor vehicle. So the phantom would be an uninsured motor vehicle. So, even though they were a pedestrian, there's a way for their car insurance to protect them.
Interesting. Okay. We got an email question from Lynn. When an older loved one reaches the point of being unable to drive safely or make good decisions about everyday things, can their children legally get the power over those things if the person is unwilling to give it up? Okay, senior parents don't want to hand that stuff over. Can you make them?
I mean, it's a difficult situation, and what you're looking at is trying to go to the probate court and say, look, this person's incompetent or not capable of handling their own affairs. I need you as the court to appoint a guardian in that situation. The court's going to be, unlikely to do that unless there's some medical doctor that comes in and says, yes, this person's a danger to themselves or there are other people, and they need somebody to watch over them. If there is, medical evidence that they're unsafe to operate a motor vehicle, if they're primary care physician says no, they should not operate a motor vehicle, then that's certainly something you could present to the state and their license could be revoked. But it's pretty significant in order to go to court, and you have to have some significant evidence that this person is a danger.
If a tree on your property falls on your neighbor's property, are you liable for any damages done?
We love the tree question.
Tree questions. Everybody's got a yard, everybody's got a tree, and something's leaning, and you wonder what's going to happen.
And we've been down the wormhole on this with the tree that's right on the boundary line.
Can I cut it?
Can I cut it? Can I do it? What can I do? And essentially, the way it works is this: is if it's a tree that is solely on your neighbor's property, falls onto your property because of wind, storm, whatever, then it was a healthy tree and there's no reason to expect that it would fall, then both people are going to be responsible for their own damages. You're going to be responsible for the damage on your property, even though it was their tree, and they're going to be responsible for cleaning up their property. If the tree was, if you knew or could prove that the owner of the tree knew or should have known that the tree was diseased, decayed, or likely to fall in some, on your property for some reason that they were aware of, and they didn't maintain or remove the tree under those circumstances, then your neighbor would be responsible for the complete damages to your property as well.
Okay. How does an attorney get paid? A personal injury attorney, how do I afford to hire somebody to take care of my case if I'm not working?
Yeah. So if people get hurt, they call us, and that's the first thing they say, is this going to cost me anything? And the first thing you need to know is that we do cases on an initial consultation for free. We talk to people on the phone for free all the time. So if you have a question, we're more than welcome to call us, and we'll give you free legal advice about that question. In terms of cases that we sign on or cases that we take, we work on a contingency fee basis, which means we don't get paid if and until we collect for you for your injuries. So if we're successful at your case, proving your case, and then it results in a settlement or a judgment, we get paid out of the settlement of the judgment, and typically it's on a percentage of the recovery. In workers' compensation cases, it's limited to 15% of the recovery by statute, plus your expenses. Car wrecks had traditionally been done on a third of the amount collected. Some firms, work on 40%, 45, 50. I've seen some firms just 50 is all we do.
Wow.
And I don't do that. But in more complicated cases, you do see a higher contingency fee rate, and that's typically in medical liability cases where there's a lot of risk, a lot of expense, a lot of time going on. So if you are successful, then the recovery needs to then needs to match the amount of work that you put into the case.
A lot of expense, like hiring an expert. What is hiring an expert? What can that cost?
Yeah, I mean, you're looking at, any kind of experts can cost from $5,000 to $10,000 to $15,000 to $20,000.
And the law firm's putting that up?
Yeah, the law firms put that up
hoping to win.
To prove the case.
Going to take a break. Be right back answering your questions. It's Ask Us Anything night. If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake with Timberlake League and Brooks in Huntsville, 256-536-0770 or 800-804-2502. They are personal injury attorneys, so everything from car accidents to medical malpractice, nursing home negligence, 256. Also check out www.law-injury.com.
Yeah, and Sharon is an excellent family law attorney in our area. And she's available in Huntsville and surrounding counties, 256-539-7337, and she can be found at sharonfamilylaw.com.
Thanks for all your questions. We'll see you next week.